Counties and states across America have begun instituting limits on public gatherings, even forcing restaurants and bars to close. In response, a handful of businesses have threatened to ignore these bans, calling them unconstitutional. Do they have a legal leg to stand on? For that, I'm joined by Michael Papantonio, longtime trial attorney and host of America's Lawyer with Mike Papantonio, and he joins us from Pensacola, Florida. Can businesses defy any state rulings that they shut down?
Larry, there's something that's called, it's a constitutional concept called police power. It comes from the 10th Amendment of the Constitution, and it allows a state official, a governor, or even a mayor to determine where health, safety, or welfare of the people living in that community are at risk. They have the chance to take very extraordinary steps. For example, the case that you see, a couple of cases developing right now where attorneys are trying to say you can't close my business. It's really, really bad advice. The government can close their business because this power allows them to actually do fairly extraordinary things. One extraordinary thing that they can do is they can quarantine an entire area. That involves closing down bars, it closes down businesses. They can even tell you, go to your house and don't come out because there is a curfew. So this concept of police powers, again, it comes from it comes directly from the 10th Amendment right for a city or a state to say, we're going to take some extraordinary steps, but we have to do that to protect health or safety or welfare of a community.
The federal government was admittedly late in this, calling it a hoax at the beginning. Can we sue the federal government for being late?
It's going to be very difficult to do that, if not impossible. There's certain immunity that government officials have where it comes to making administrative decisions. They can be really bad decisions, but for us to make the argument that, gee whiz, you didn't do what you should have done when you should have done it is a pretty weak case. There may be some people that give it a try, but ultimately by the time SCOTUS takes a look at it, they're going to find that there's plenty of precedent to say that's not a viable claim. It doesn't mean it can't be done, but the viability of that claim won't be long-lived on the appellate courts.
Mike, tell us what legal issues might occur after all this is over.
I think one of the biggest issues that we're going to see is we're going to have insurance companies that insure businesses, Larry, and they're going to be saying, we don't owe you any money for business loss. They're going to say, if you look at a typical business loss policy, what you'll find is there'll be this language that there has to be some physical impact to the business before you can make a claim. There's all types of predicates that they use to get past that. If you take a look at any of these policies, it's kind of boilerplate language. The chances of these insurance companies actually pulling through and pulling that off are very slim. In the right jurisdiction, the argument's going to be, look, we had to leave our business. The physical impact, you can't see it, but it's a virus that has potential to kill my employees and kill the people who want to use my business. We would take those cases all day long. There's going to be big pushback from the insurance industry, Larry, because they're going to do what they call setting reserves. What they do is they put an amount of money to the side and they say, this is reserve money. A, it's not taxable. B, we still can make money on that money that's set aside. It's almost tax-free interest that they're making all that money. So they understand that in something as big as this, we saw it with BP right here on the coast, for example. You had insurance companies saying, no, we're not going to cover that, and we really had to get involved in some litigation to make them come around. We're going to see the same thing here. Businesses that legitimately have been ordered to close down because of this virus have a right to a business claim. And you're going to see a big fight taking place between businesses and insurance companies.
Can cities in Florida round up those people out on the beach, and there are a lot on beaches today, and send them home by edict.
They absolutely, the governor of Florida today could make a pronouncement that the beaches are closed. Again, it comes down to this extraordinary power that's given to the states. Larry, this power goes all the way back to the Revolutionary War. In Philadelphia, during the Revolutionary War, there was yellow fever. So they literally rounded people up, put them in stock, actually put them in a forced quarantine, took them off the road, and did that as routine. The same thing can happen in a state. A municipality can do that. They can say, you're posing such a public health. We're relying on our police power through health, safety, and welfare rights that the 10th Amendment gives us, and we're going to take an extraordinary step. We're going to close this beach. If you're on the beach, we have the ability to remove you from the beach. So the answer is yes. Hasn't gotten there yet in Florida, which I think is extraordinary, but I think it's going to get there very soon.
President Trump can invoke the wartime authority, and he has, that allows him to ban entry into the United States, speed up production and resources to be used in the fight against this pandemic. Do you agree with allowing him that?
Well, he has the absolute right, Larry. It's I think it's 42 code. I don't remember exactly. It's 42 code, I think section 200, 230, maybe 260, that it's right there in the code that he has the absolute right to slow down the flow of immigration. He's already doing it in Canada. He's saying he's not going to close the border on Mexico. I think it's just a matter of time that happens. Yes, but that, and Larry, that is another one of those extraordinary rights that if you push it up, if you say you have this right, President, and you have this right that and if you balance it against issues like equal protection or due process, most of the time, that police power that he has is going to trump it every single time. Same way with the state. If you have an equal protection issue or you have a due process issue, most of the time, the police power is so strong that it's going to be an extraordinary showing that there's been some due process violated or some equal protection violated. So to get to the quick answer is yes, he can do that. It's going to be held constitutional. Anybody who tries to test it is going to be wasting their time. The appellate courts are going to rely on not only on precedent, but they're going to rely on, I think it's 42 U.S. Code is where he has the right to do that.
Mike, as always, thanks for your insight.
Thank you, Larry.